Hi, my name is Holly Haggerty, and I have the distinct pleasure of introducing our wonderful guest today. Joryn Jenkins has been practicing law for nearly 40 years. She has a wide variety of experience, including working for one of the 10 largest law firms in the country in DC. She has worked as a government attorney in a mid-size and a small boutique firm. She has taught law school at Stetson University, and now in her firm, Open Palm Law, she is herself a small business owner. Joryn is a published author and has written 9 books on collaborative law, as well as a poetry and a memorabilia cookbook. She's the only practicing lawyer in Florida to have been awarded the prestigious A. Sherman Christensen Award presented in the United States Supreme Court. Only one person a year earns this honor. A federal judge once explained that Joryn's most admirable traits are her dedication, innovative spirit, and hard work. I've had the distinct pleasure of working with Joryn for nearly 2 years doing her digital marketing, and I can say that I've observed the same dedication, spirit, and work level as that judge. Without further ado, to introduce you to collaborative law and her mission to changing the way the world gets divorced, I will turn this over to Joryn Jenkins.
I'm here right now to talk about offering a healthier alternative to families. Obviously, you've heard a bit about my background, and in listening to Holly, it struck me that there's really no reason for you to believe that I can speak to divorce. There's no, what's my expertise in that area? And we've probably all been touched by divorce. When I was 7 years old, my parents were divorced, and my mother loaded us kids into the van and moved us 3,000 miles away, and I never saw my father again. Still, I had a judge walk into a courtroom one day with my new client sitting next to me, and the judge introduced himself to the clients and said, "Oh, you've got wonderful lawyers. I don't know anything much about divorce. Joryn will tell you that. We used to practice together when we both did commercial litigation, but how hard can it be? After all, I have a family." So apparently that made him an expert in family law. And the fact that my parents were divorced doesn't really make me an expert in divorce. I've been divorced, so I know something about it from that perspective. And then I married a guy who was going through a pretty horrifying post-divorce situation. So from that perspective, I know a lot. And then, of course, I've represented folks for a long, long time. I hate to tell you, it's been 40 years. And you get a lot of experience when you're representing families in court. Experience that you may not necessarily want to tell people about, because what I really learned in the court divorce process is that families don't belong in court. I started in commercial litigation, and that was all well and good. Business in the courtroom, it's just business. Sure, emotions can get up there. There's no question about it. But families, every family I've ever met is unique. You may live next door to a guy who has the same years of experience in the same industry doing the same thing. His family is still unique. It's not the same as your family. And therefore, after 40 years of doing this, I've realized that every divorce should be unique, and judges can't really do cookie cutter divorces, and they do every day because that's the only thing they can do. So we're here to talk about a healthier alternative. And when I say healthier alternative, I mean out of court. What processes are there that can help these folks without them having to go to court to get a result, to get separated, to get their family restructured? Because after all, when they go to court, their family gets destroyed. Robin Williams said, "Oh yes, divorce, from the Latin word meaning to rip a man's genitals out through his wallet." And then he went and got a collaborative divorce. So apparently I'm guessing that he first had a courtroom divorce, and maybe the second time around got a collaborative divorce. Mary Kay said that divorce is the psychological equivalent of a triple coronary bypass. a little stressful, I think is the point that she was trying to make. Craig Ferguson said divorce lawyers stoke anger and fear in their clients, knowing that as long as the conflict remains unresolved, the revenue stream in the lawyer's pockets, obviously, will keep flowing. And that, unfortunately, has been my experience to a large degree. Lawyers know that the longer their clients fight with each other, the more money that they'll make. And that just isn't fair to families. So I don't know if any of you have heard of collaborative law yet. It basically is an out-of-court approach to divorce. I'm going to talk first about the collaborative team. I'm going to talk a little bit about the background of collaborative divorce. Then I'll discuss the principles that we adhere to in the collaborative divorce process, because there are principles, there are rules, and there are reasons for these rules. They've developed over a number of years. The first guy to think about approaching divorce in this way was named Stu Webb. He was in Minnesota, and I think the year was 1991. I think it was 1991. We've been doing this for 26 or 27 years, so help me with my math there. So why is the collaborative divorce process more desirable and successful than traditional courtroom litigation? And that's where we're going to start. When you're getting divorced, it makes you feel isolated and alone and pretty much unsure of where to go for support. Most people call a lawyer first, and that's fine. It doesn't always work well if the lawyers aren't trained to tell their clients what all the alternatives are. So most lawyers will say, like my lawyer did when I went to get a divorce before I started doing divorce work. He said, fine, I'll file a petition. And I looked at him and I said, are you kidding me? I have to go to court to get divorced? I mean, this is how little I knew about divorce. I was a commercial litigation lawyer. I did business transactions. I did business breakups. I did breach of contracts. I did all that stuff. When he said I had to go to court to get divorced, I about had a heart attack. I said, you'll laugh. I said, are you kidding me? I didn't have to go to court to get married. And he laughed. And we went to court because that was pretty much what the choice was. Now, everybody knows about mediation. Mediation has only been around since 1980. And it wasn't a thing until the courts started pushing it, because the dockets got bigger and bigger, and the courts realized, oh, you know what? We should suggest mediation because it works 9 out of 10 times. So why not? So this guy came up with this collaborative divorce concept, but we've been doing mediation for a while, and people think collaboration is the same thing. It is not. We do arbitration in some states. It's not the same thing. We do negotiation, just plain old cooperative negotiation. Those are lawyers who know each other and work with each other fairly regularly and respect each other and feel like they can trust each other. And I think that makes a difference for people. I have a poster in my office that I go through with all my clients when they first come in. And in fact, I will meet with both spouses and go through this poster. I'm not giving legal advice. I'm telling them what the processes are. I'm basically teaching a class in what their choices are to get divorced. And we talk about negotiation and cooperation, collaboration, and mediation and arbitration. The thing is that I also have a poster right next to it. So I've got these choices, and they get more and more complex. And then in the next poster next door, I've got the same processes, and I've got the costs. And of course, the costs aren't flat fee. I don't say, okay, I'm going to charge you $5,000 to do your mediated divorce. No, I still work hourly. I can't charge flat fee. But I've done enough cases that I can tell these folks what the average costs are and what the average amount that they'll spend will be. And if they're by themselves and they don't have their spouse, they'll go home, they'll take a copy of the poster with them, a little handheld, and they'll go through the choices with their spouse if they're still talking. If their spouse has already hired a lawyer, they can still talk to their spouse, but I can't. So then we try and get around that, because If the other lawyer went straight to court, then they've already pretty much shot across the bow of their spouse's ship, because the petition that gets filed in court is nasty. It's just nasty. So let's say you're the stay-at-home mom. Not so much of that these days, but let's say you're the stay-at-home dad, you're the stay-at-home mom, doesn't matter. You both agreed during the marriage that you would stay home and homeschool. And you get this petition, and the petition says that I, the other spouse, want 100% custody. I don't think you should have any custody at all. That's what the petition says. It says, I want my attorney's fees from you. Now, I may be the one who's making all the money in the family because we agreed that that's how we were going to run things. But now we're getting divorced, and my lawyer said that I have to put in there, I want you to pay my attorney's fees. When I said to my lawyer, I don't understand that, the lawyer said, well, it could take us 3 years to get you divorced. And in that time, you might lose your job. And you might need to ask for attorney's fees, but if we didn't put it in the petition, we can't get them. So there are reasons why the petition is written the way it is, but the other spouse gets that petition and just goes, oh my God, what the hell is going on? And she runs out and she hires a lawyer, and that lawyer does his normal thing. So in collaboration, we require a training because lawyers don't know this stuff. This is not learned in law school. We don't learn it in law school most of the time. There are a few law schools that are starting to teach, certainly they're teaching mediation. Some of them are starting to teach collaboration. So we have a specialized training. It's 2 days long, and it really teaches a new mindset. Team members are trained to work together to help the clients achieve their goals and their interests, not their positions. And that's a critical element. The training establishes that the clients control the focus, the decisions, and the pace of the process. And this is key to maximizing their satisfaction with the results. So a courtroom divorce will cost you more. It will take more time. Some judge who doesn't know you or your kids or share your values will make decisions that will affect you not the next 18 years or however long it takes for your youngest to turn 18, but actually for the rest of your lives. Because if he decides that you should only see your kids on weekends for some reason, then you're only going to see your kids on weekends, and you're not going to have the full parenting experience that you might otherwise have, as an example. So the judge makes the decision, not you. And the biggest thing that really impacted on me was that in the collaborative approach, we protect people's relationships. So when you're that spouse and you get that petition that just creeps you out, because after all, you opened the front door when the doorbell rang because you thought it was the delivery guy, and it is a delivery guy, but he hands you a sheaf of papers and it has a petition in it, and he says, you have 20 days to answer. That's scary. That's pretty awful. That's the shot across the bow. And now you're at war. Now you're angry. You weren't angry before, but now you're angry. And when you go to your lawyer and he explains to you what's happening, you get angrier. And once the anger starts, even if there wasn't anger before, it will start when you go to court. Because in court, every little thing gets blown out of proportion. So let's say you've been together for 20 years. One of you smokes marijuana. One of you drinks a glass of wine every night. The marijuana was not an issue between the two of you. Maybe it should have been when it was illegal, but it wasn't an issue. Now you're getting divorced and you're the spouse who drinks the wine, and you mention to your lawyer, well, you know, my husband smokes dope every night when he comes home from work. It's how he unwinds. And the lawyer, knowing what he knows about how to go to court, blows that so out of proportion that the husband is now infuriated because all of a sudden his minor use, small use, occasional use, whatever it was, of marijuana has become, he's a drug addict. And that's what happens. That's what happens when you go to court, not in collaboration. The team works very hard to keep people calm and kind to each other. And we learn that in a training. We also learn that with experience. It takes some time. The first few cases I did were not nearly as kind to each other, although I have to say some of my earlier cases were truly amazing. I've got a book, one of the first books I've written, the book that Holly mentioned, the recipe book that I wrote for my daughter, was earlier, and there was also a book on motion practice, not your most exciting book, but I've written a book called War or Peace. You can find it on one of my websites. You can find it on openpalmpress.com. It's also on Amazon, War or Peace. It's about collaboration. It's about the collaborative approach, and it's got some stories in it. There's one story I particularly like called The Secret, where probably my fifth or seventh case, the husband, who was not my client, told his wife a secret once they were in the safety of the conference room. It was a safe place. He felt safe. His lawyer was right next to him. The facilitator was there. I was across the table. His wife was next to me, and we had our financial neutral in the room. And he told this secret, which explained why he wasn't able to contribute to his daughter's Sweet 16 party, which was what had instigated the divorce. They'd been separated for a while, but she was really angry. And she was angry because he refused to pay her some extra money for the Sweet 16, which sounds like it wasn't a big deal maybe to you, but to her it was. And he explained to her why, what had happened. And it was something that happened 5 years earlier. He'd never told her in the moment. And there was a reason for that. And she got even angrier when he told her the secret. So I called a break. We went into a side room and I said, "Why are you so upset? He shared the secret with you." And she was upset because they were best friends all through school and through the first part of their marriage. He hadn't shared the secret with her, and she was incensed that he didn't feel that he could trust her. And I said to her, "But don't you understand? He didn't share the secret with you because he values your respect so much that he couldn't bear to do it without our support." And she just was so taken aback by that perspective. It just opened her mind. You could see it happening. And we got those people divorced. We worked through all the other issues, or a lot of financial issues. We worked through all those other issues. We all went to the courthouse together because at the end of the day, you still got to get a final judgment from a judge. But this final judgment was basically just approving their agreement. So we all went to court, the facilitator, the financial neutral, his lawyer, me, I'm the lawyer, both of the clients. We go to court, we get them divorced. And the judge was this was one of the early cases in Florida. The judge was very complimentary. It was Laurel Lee, who's married to Senator Lee. She was very complimentary. And we left the courthouse and the clients are walking ahead of the rest of the team. And I see the wife throw her arms around his neck and hug him. And she says out loud, "I hope you know I will always love you." And that really hit me hard in the heart. So that was one of my earlier cases. So you've heard me talk about who's on the team. You've got the husband, you've got the wife. You might have an unmarried mother and father. These work in paternity cases too. You might have an ex-husband and an ex-wife. Maybe they got married, maybe they got divorced in court, but now they've heard about collaboration and they have some post-judgment issues. They want to make some changes. So they've come to a collaborative team for help with that. We've done a couple of employment cases with this where I represented the employee and someone else represented the employer. Those are divorces too, in a way. And we've done a couple of partnership breakups, same thing, divorces in a way. So you've basically got 2 or maybe 3 or 4 clients in the room. Every client has a lawyer. And those lawyers, the definition of a collaborative divorce is the two or more lawyers sign a written agreement that they will not go to court to resolve this dispute. That's the definition of collaborative divorce, of collaborative law. And that's all that's required. Now, having said that, I have to say that we often have a financial neutral. So unlike courtroom divorces where you've got financial experts, this person is a financial expert, but they are specifically neutral. So in your normal divorce, I would hire an expert CPA and the other side would hire an expert CPA, or I might hire an expert business valuation person and the other side would then have to hire an expert business valuation person. Or maybe I hire an expert certified financial planner to talk about breaking up the marital assets. The other side would hire their own. So in a collaborative divorce, we only need one expert because he's neutral or she's neutral. In divorces, we ramp up the costs because I have my expert, you have your expert. So now we've doubled up the money. Except we haven't. We've actually quadrupled up the money, and here's why. In a courtroom divorce, my expert has to prepare to give his opinions. And he's also got to help me prepare to tear down the other side's opinions. And that happens on both sides. So now we've doubled the expert's work twice, one for each expert. So that's one of the ways that we minimize costs. Another way that the costs are minimized is that the financial neutrals actually generally charge less than lawyers. So my normal hourly rate is $500 an hour. I went to Yale when I was 16. I graduated when I was 19. I went to Georgetown Law. You've heard my background. I have 40 years of experience. So I am able to charge that hourly rate and get it. People come to my office knowing full well that I charge $500 an hour. A CPA, similar experience as mine, probably charges $250 an hour. In a collaborative divorce, I'm not the one who does the financial affidavits now. Now I have a financial neutral, a very specialized person who really understands financial affidavits, and he's the one who does that work for me. The financial neutral, and he's only charging half of what I'm charging. So another way that we save money. Now, there's another neutral person that we typically use in these divorce cases. And that person is a mental health professional of some kind, psychologist, social worker, I forget what the other terminology is, but family counselors of one kind or another. There's several of them. Licensed mental health practitioner, that's one. Any of these people can get trained in collaborative divorce, and we use them as facilitators. And that's what we call them. We try to avoid telling people their mental health because people think, oh, I'm going to get therapy, or, oh, my husband needs therapy. No, these people are facilitators. There's no therapy involved. There are approaches that might look like therapy because the facilitator really digs deep with the clients to talk about what their goals and interests are. Now, let me talk about that for a second. I've had many clients over the years tell me, I want the house. You've been touched by divorce. Everybody's been touched by divorce. 50% of all marriages end in divorce. So it's likely that you've been touched by divorce one way or another. 67% of all second marriages and 74% of all third marriages end in divorce, by the way. That's because if you go to court, you don't learn anything. You learn just how to go to court. So get married again. I like to argue that if you've gotten divorced collaboratively, you probably won't get divorced a second time because you'll know how to work things out better, but you don't learn that in court. In any event, the mental health professional talks about goals and interests, and I have these clients who say, I want the house. And they've said that to me for years and years and years. It wasn't until recently that I figured out they don't really necessarily want the house. What they really want is the security. They don't want the upheaval. They're getting divorced. Don't make me move also. What are the top 10 stressors? Divorce is one of them. Christmas is one of them. Relocation is one of them. Couple divorce and relocation in the same situation, and you've doubled up your stressors. Oh, and by the way, divorce is so much like death. It's worse because if you didn't want the divorce and your spouse is still walking around happy as a lark, getting remarried, it's worse than death. It's worse than if he had died on you. So divorce is excruciatingly stressful. I say it's the top stressor ever. And when you add relocation to it, it makes it worse. So I've had many clients who, I want the house. I had to figure out how to explain to them that they couldn't afford the house and that they would not afford the house even if they got alimony. I've had clients come back to me. I've stayed friends with a lot of my clients, and I've had glasses of wine just checking up on people a year later, even if we weren't friends, just checking up. And I've had clients say to me, you know, you were right. I shouldn't have kept the house. I ended up filing bankruptcy. I ended up filing foreclosure. I didn't need the house. I just wanted the security of staying where I was. Or maybe they want their kids to stay in the same school system. We can satisfy that interest, but you don't have to have the house. That's a position. The interest is, I want my kids to stay in the same school system. The interest is, I want home office. The interest is, I want my kids to have separate bedrooms. I want them in the same neighborhood where their friends are. If you can figure out what the goals are, what the true underlying interests are, then you can negotiate. Then you can figure out different answers to the same question, different solutions to that question. That's the job of the neutral facilitator. So the neutral facilitator sits with both clients and figures out what the goals and interests are, and then communicates that with the rest of the professionals so that we know. We also know through the facilitator what kind of people we're talking to, what kind of emotional turmoil they're in. Is this the one that wanted the divorce, or is this the one that is avoiding the divorce? Is this the one who is highly emotional? Is this one hiding his emotions? Is this one overly attached to the children? Is this one regretting that he didn't spend more time at home with the kids? We dig deep, and the facilitator is the one who helps us do that. There are other professionals that we can bring into the process. In theory, we could bring a real estate person in, and I've had realtors get trained in collaboration specifically because they wanted to do this kind of work. I've had vocational counselors get involved and get trained because they wanted to know about this kind of work. Generally speaking, however, we have that 4-professional core team. The neutral facilitator who leads the team and the meetings, by the way, that person is usually in charge. Believe it or not, that person is usually in charge. And it takes a special kind of facilitator. I've had many MHPs, we call them, mental health professionals, get trained in collaborative divorce who dropped out because it wasn't in their nature to be the leader of the team. There have been a lot of lawyers who dropped out because it was in their nature to take charge. And generally speaking, neither lawyer takes charge in a collaborative divorce because it would make the other lawyer look weak. And we don't want to do that in front of our clients. We want the lawyers to be even. And that's why the facilitator is usually in charge. The facilitator might help one of the parties manage the pain of ending the relationship, might help one of the clients manage the stress of the process, keeps them focused on their ultimate goals, reminding them of what their goals are, because you can get angry about something and lose sight of the goal. How many times has that happened in your life where in the middle of an argument, you found that you really lost sight of where you had come from and where you were going? You were just angry because of things that were said. And when the argument was over and you thought about it, you regretted what had happened in the moment. That's the facilitator's job, is to keep the clients focused, to call a halt to a meeting like I did with the wife when she was getting angrier about what was going on and I didn't understand why, so I needed to talk to her and redirect her. The facilitator also keeps the meetings on track and productive, so we get an agenda from the facilitator, which we all have input into, and then we stick to it because nobody wants to be surprised. we don't want either client to feel like they've been sandbagged by the team. And then these neutrals, both of them, may meet with the clients outside of our joint sessions to do work outside of the joint session. So again, let's say the clients might meet with the neutral financial person to do their financial affidavits. I don't have to be there. You don't have to pay me to be there while the expert is helping you with your financial affidavit. The clients might meet with the facilitator to discuss a parenting plan. I don't have to be there. The parenting plan that I usually will do in a divorce, each attorney will do a parenting plan and they'll have competing parenting plans. No, in this case, the facilitator will usually do a master parenting plan that she works with both of the clients with to get a result that they can agree on. The rest of the team may get involved helping with the parenting plan or may not. The facilitator may be able to get that done with the clients. That piece gets done and saves money. The lawyers don't have to have input on that. So that would be some of the side meetings that go on. Of course, the client might meet with me. The client might want to meet with me to talk about disclosures. There's one thing about collaboration. It's very transparent. So you can't hide stuff in collaboration. It breaks, that's one of the rules. It's very confidential. So I've had many judges. I have a case right now with a judge where the judge chose collaboration, didn't really understand what collaboration was because not everybody knows about it yet, but knew that he wanted collaboration because it's confidential and he doesn't want his information out in public. This is one of the big things about collaboration. Many people don't understand that you file your paperwork in public. It's public disclosure. So your financial affidavits are out there for the whole world to come look at if they want to. Your 16-year-old can get in her car and go down to the courthouse and look at it. I had a client who came back to me a couple of years later to tell me this story. She said, you know, you got me divorced. You did a great job. You got me wonderful alimony. My husband and I are getting along just fine. This was a courtroom divorce, but we mediated it. I was about to get married. And I got to tell you what happened. She's sitting in the nail salon and her friend sits down next to her. Friend she hadn't seen in a while. The friend says, congratulations, I see you're getting married. And my client says, yeah, I'm excited. We're getting married in a week. And I've known him for probably a year. And he's just a wonderful guy. And the gal says, the next gal at the next table says, you know, I met him a little over a year ago at a cocktail party. And he told me that he'd heard about your divorce and he knew that you were getting alimony and he knew how well you had done in the divorce and he was going to woo you and he would marry you. And my client sort of absorbed this information and then said, how did he find out all that stuff about me? And the gal said, oh, it was easy. It was in your settlement agreement. He went down to the courthouse and he looked. But I'm glad it's worked out for you. Apparently, the friend assumed that the romance was real on both sides and not a setup. But my girlfriend, my client, went back to the guy and challenged him and figured out that he had stalked her and her kids because her parenting plan was published too. It's public. And it said what school the kids were going to. And now we are making a lot more of that information confidential by hiding the kids' names, for example. But the mom's name is on the top of all the paperwork. So you just have to figure out who the mom is, find her. And if you know the school the kids are in, it's not too difficult to put one and one together and get two. The kids were on the soccer team. He knew that. So he volunteered to be a soccer coach. And that's how he stalked her. Their first date, he saw her in the stands and invited her out for a cup of coffee. Needless to say, at the end of the day, this gal did not marry him. but she was appalled that her information was so public. I think we're doing a better job at keeping courtroom information less public, but it's still public. And so we still have judges coming to us to help forces and keep that information all confidential. So I talked about the fact that I do consultations with both spouses. I had one consultation where the husband brought his wife in, and typically what I'll do is I will be very clear that whoever made the phone call to our office is the one who will be our client. I don't want to start their divorce by them arguing over which one is going to get to hire me. But this case was interesting. The husband brought his wife in. He was a business owner, big business actually, big in my eyes. He had 400 employees. And she was a second grade school teacher. And she was the epitome of a second grade school teacher. Lovely gal, very soft-spoken, demure, let him be the boss. It was clear, let him be the boss. Throughout the divorce process, he was the boss, pretty much. And they're sitting there, and I go through my divorce process options and costs options. And they start to have a discussion in front of me. And he says to her, so I think we just mediate. Let's use Joryn. We can use her as a mediator, which was fine with me, because if I haven't given any legal advice, neither one is my client. I can be their mediator. You can't give legal advice when you're a mediator if both of the clients are your mediation clients. So they don't have lawyers, or they can both hire lawyers. That's another choice in the processes. They can both hire lawyers. And at that point, she said, no, I want a lawyer. And he turns to her and he waves my book at her, because they'd each gotten a copy of my book. I give my books to all the consultations so that they can learn something about collaboration and the rest of the processes. And he waves my book at her and he says, well, are you going to hire Joryn or am I? And she goes, and this was where she asserted herself. She said, oh no, I'm going to hire Joryn. So they agreed that she was going to have a lawyer. He still wanted to mediate. But when she said that she also wanted a financial neutral, he decided at that point, okay, let's do this the collaborative way, because it sounds like that'll work better for both of us. So we agreed that they would each get a lawyer. And by the way, because he gave her the option of who's going to hire me, I went with that because that was fine with me. I didn't care. So she hired me. He got a list of 3 lawyers from me, lawyers that I've worked with, lawyers that I've collaborated with before, that I know are comfortable with the process. And he hired the first one on the list, and we picked a financial neutral. And at that point, I called the other lawyer and I said, okay, your client did not want to have a facilitator. He thought we didn't need one. But my client is really soft-spoken in this relationship, and he's very driven, and he's definitely the leader, Briggs-Myers personality type. I really think that we need a facilitator to help us all stay on track here and not let him take over the process. What do you think? And the other lawyer absolutely agreed with me, but he said to me, so I've perceived the same things you've perceived about my client. I think the best way to get him to agree to a facilitator is for her to say that she wants one. I think if she says that, he'll agree to it. So I went back to her and I said, okay, you need to tell me that you want me to tell him that we need a facilitator. And she did that, and I did that, and we got a facilitator. So now we had our team. Usually the 2 lawyers will pick the 2 neutrals if the lawyers are first into the process. Now, sometimes a marriage counselor will be the first person into the process, but if they're the marriage counselor, they can't be the facilitator. What they do is they refer into the process. Same thing for the CPAs. Let's say that a married couple uses a CPA every year to do their taxes, or a CFP to do their assets. Those people can refer into the process, and often do, because that way they get to keep the clients. In other words, a lot of people who get divorced, I'm never using that CPA again because my husband hired him to begin with, or because my husband's going to continue using him, so I'm going to use someone else. CFP is the same thing. My husband still has his assets there. I hate that guy now. I hate him. So when these people refer their clients into the collaborative divorce process, the process is so much more fruitful, and it's a kinder, gentler approach. Very often these type of outside peripheral, let's say family employees, they're not, but they work for the family. They remain employees of the divorced people. And so they keep their clients that way. So sometimes those people will refer into the process, but most people, first person they talk to about getting divorced is their lawyer. And when that's me, I get the other lawyer on board either by referring specific names to the clients, or by referring the other client to the website. There are two websites in Tampa. One is Next Generation Divorce, and one is Tampa Bay Academy of Collaborative Professionals. So Next Generation Divorce they're two different practice groups, a lot of the same people in the groups, but they have different interests. And so I refer people to both groups, and they can find professionals listed on those groups and pick their own lawyer. They're there. They can go interview them, handle it as they will. When I find out who the other lawyer is, I will get in touch with that lawyer. We'll choose the neutrals, and now we've got our team. In the collaborative process itself, once that written agreement where the lawyers agree they won't go to court is signed, then we start the process. And that involves establishing ground rules for the couple. They know what the protocols are. They know that we try not to blame. What's past is past. We're moving forward now. We're looking into the future. It's not about what you did. This pointer, this finger pointing. I have a whole poster about gestures and facial expressions to avoid and to use that will help. Body language is so important. 93% of our communication is body language, right? So I think 34% is tone of voice, and 50%, 57% is the actual physical. This is why putting on webinars is a little difficult for me, because I'm very physical when I put on my presentations. I'm very in the room. I'm walking around and I'm gesturing. But body language is very important. We're doing collaborative cases by Zoom these days, and it's not as hands-on. It's just not, but it's pretty good. I think we've all discovered in this environment of quarantine that GoToMeeting, Zoom, WebEx are a lot more helpful than we ever knew they were. And I don't think they're going to go away. I think we're still going to continue using these processes. So we establish the ground rules. We identify the interests and concerns and the goals and interests. We put them up on a blackboard or on a whiteboard at the beginning of every meeting, so that we can continually refocus the clients on where they want to be at the end of the day. We address temporary issues early, get rid of the things that are stressing people out, like if they're both in the same house, which one's going to move out. Try and take care of those issues early before the stress derails the process. We gather information. It's a transparent process. Maybe the clients have kept their finances separate. The case that I'm doing right now with the judge, they've kept their finances entirely separate because they were both divorced in court before. And so now they're sharing information. We gather information about how the kids are doing in school, all kinds of information, anything pertinent to the divorce, the restructure. And then we brainstorm options. So what are the problems? What are the potential solutions? And when we brainstorm, it's every idea in the world. We throw it out there. Doesn't matter if it's stupid, silly, brilliant. It doesn't matter. We don't judge ideas in the room. We just throw them out there, because a silly idea could actually get you thinking about something. It might generate a perfectly valid idea, a perfectly valid option. And then we evaluate the options. What happens if we do this? And so then we decide, no, that's silly. We're not going to do that. And then we select the best available options. So I have that process. We call it the roadmap, the problem-solving roadmap. I have that in a poster, because posters help people tremendously. Especially, I had a couple come in to see me, both of them, and the husband was very frowny. He made me uncomfortable. I was very nervous. I talked quite a bit the first 5 to 10 minutes. And of course, it seemed probably longer than it was because he was frowning. And he finally looked up and he grinned. And I'm like, okay. And he said, oh, I get it. I get the posters. The posters are for people like me because I'm very visual. My wife is not. She's not visual at all. She's a reader. But I'm very visual and I totally get what's going on here now. So proof. The proof was in the pudding, as my grandma used to say. The posters are very helpful to me in my cases, and I use them during the full team meetings. I use them in my one-to-ones with my client when I'm getting them prepared for a meeting. You know, avoid these gestures, don't do this, try and be more open and open to ideas, and, you know, that's pretty much the problem-solving roadmap. Divorce really affects a lot more people than you think it does. I've had people come to my office and say to me, I got a subpoena the other day. I don't know who sent it to me. Can I show it to you? And it turned out that they were the next door neighbor of a couple that was getting divorced, and they were being subpoenaed to court by one spouse or the other. And their biggest concern was, who am I going to be living next to when their divorce is over? And are they going to be mad at me or not? I don't want to say something that's going to hurt somebody. And of course, I've seen things that seem to have gotten blown out of proportion. So this is a neighbor who had to pay a lawyer to represent him or her in that divorce. I've had grandparents come to me and say, do I have any right to see my grandchildren because my kids got divorced and now the wife won't let me near the grandkids, and the dad only sees them once a month or whatever it was. I mean, just some horror stories. And I've had grandparents come to me who, I just finished a maternity case, as a matter of fact, where the grandmother was using her retirement funds to fund her daughter's side of the case. I had a divorce where the grandfather was funding his son's fight. In that case, actually, the grandfather, it was really the grandfather's fight. I represented the wife and we fought for years in court. I finally got them divorced and he appealed. He appealed that case 4 times, and then all of a sudden it got and we won every time. And then all of a sudden it got very quiet. Nothing happened in court. It just, all of a sudden it was, and after a month of that, I called my client and I said, I haven't gotten anything in court, and that's weird because we constantly were getting stuff. And she said, let me check and see what I can find out. And grandpa had died. And at that point, the husband stopped fighting. So all of us are impacted by divorces around us, not our own, not our parents. Teachers are affected. They get subpoenaed. They have to take a day out of school. They don't want to do that. Principals, they don't want to do that. A lot of people are affected by divorce. And if you're doing a courtroom divorce, it's the worst choice you can make. Now, having said that, understand the choice is both spouses. If one spouse insists on going to court, the other spouse can't stop that from happening yet. I can tell you that the judge will order people to go to mediation before they're allowed to have a temporary hearing in Hillsborough County, and before they're allowed to have a final evidentiary hearing pretty much anywhere in Florida. They're going to order you to go to mediation because 9 out of 10 cases settle in mediation. But I will also tell you that 9 out of 10 cases settle in collaboration, and collaboration is a lot more educational for the clients. They learn to co-parent, they learn to communicate, they learn to talk again. I had one client leave the divorce, not my client, the husband. He debriefed with his lawyer and he said, I became a better person because of my divorce. His wife who was my client, said, I learned to listen to my husband again. It just sounds different when someone else says the same thing he just said. So they actually learn to hear each other again, which I think is critical for post-divorce communications. They're not going to go back to court. They're going to work things out, or they'll come back to the team. It's just much more smooth. So I advocate it highly. If you ever want to talk to me, I'm available. I'm always available on my computer. I hate to tell you, my husband hates to tell you, I'm always available on my computer. It's Joryn at Open Palm Law, because an open palm holds a lot more than a closed fist.